This short video will tell you when police are permitted to use force according to the Constitution. So the Constitution's Fourth Amendment is the amendment that the Supreme Court has said governs police use of force in seizures and arrests of people. And so the Supreme Court's had basically three opportunities to think about when is it that police get to use force. And two of those cases really kind of center around when police specifically get to use deadly force, but all of those cases are going to tell you what kinds of constraints the court thinks are on police use of force. And the kind of spoiler I will give you at the beginning of this is the Supreme Court doesn't think that there are too many specific constraints. And so I'll walk you through the three cases, and that'll give you some framework for thinking about when is it that police get to use force. But understand, the Supreme Court is not going to give you some sort of checklist or formula that's going to allow you to figure out, under these circumstances, what kind of force can police officers use. Those are decisions that oftentimes get left to individual police officers, police departments, state law, and so those might be better avenues for trying to address police use of force than trying to use the Constitution, at least at this point. So the first time that the Supreme Court really considered police use of force in the modern era was in a 1980s case called Tennessee versus Garner. And this case involved a teenager who had been reported as maybe committing a burglary at a house. And when police arrive, they say they see this very small, very young teenager trying to climb a fence to get away from them. They can't catch up with him, and so they shoot him in the back. And they specifically say, we didn't think that he was armed. And so the Supreme Court considered in that case, can the police constitutionally use deadly force under those circumstances? And the reason that they were being asked that question is traditionally at common law, actually police could use deadly force to apprehend anyone who they were trying to apprehend for a felony offense. The Supreme Court said, well, the reason that that was the common law is because we had a very narrow set of felonies that existed at common law, very serious potential risk of death type offenses. So murder, burglary, kidnapping, things where there really was a substantial risk or somebody actually had died. And if the person got convicted of the offense, they were going to be put to death. So the decision to use force ex ante rather than ex post maybe wasn't as substantial. But the Supreme Court said in the modern era, all sorts of things that we didn't used to think of as felonies now are felonies. They were misdemeanors then, felonies now, and it's simply not reasonable for police officers in every encounter involving a felony to use deadly force, regardless of the amount of danger that the person actually has created or poses going forward. And so the Supreme Court articulated at the time something that kind of maybe sounded like a test for when you got to use deadly force. And here's what they said. If the suspect threatens the officer with a weapon, or there is probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used if necessary to prevent escape and if, where feasible, some warning has been given. So a pretty narrow set of circumstances, right? Someone who is aiming a weapon at a police officer, someone who has committed or is committing a crime that involves the infliction or threatened infliction of serious physical harm, and then only if you need to use the deadly force to prevent the escape, and then only if you've given a warning. So kind of sounded like a formula that you might be able to use going forward, but as you're going to see for the next two cases, the Supreme Court said, sorry about that, we don't actually have a formula. The second case where the Supreme Court in the modern era has considered police use of force is Graham versus Connor. And so this case involved police being called in on a case where maybe somebody had gone very quickly in and out of a convenience store. It was unclear exactly what police officers thought he had done that might be illegal. He seems to have been in the middle of a diabetic episode, and police officers used force on him that ended up leading him to break his ankle and sustain some other injuries. And so this is a question asking, was the police use of force reasonable in that case? And so the Supreme Court said a couple of things in this case that are worth keeping your eye on. Again, particularly because this case involves the use of force that led to physical harm, but probably not the use of deadly force. So the Supreme Court says, one, same kind of framework when we're evaluating non-deadly use of force. We're supposed to be evaluating, according to the text of the Fourth Amendment, the reasonableness of a seizure of the person. That's going to involve some balancing. It's going to involve kind of balancing the state's need to use the force to apprehend the person against the individual's liberty interests, interest in their life, interest in not being injured, everyone's interest in making sure that the case is at some point in the future adjudicated. So the court says this is all going to be evaluated for reasonableness, which, and here's where you start seeing this, the court says is not capable of precise definition or mechanical application. So it's going to be balancing a number of factors, but the Supreme Court is telling you we don't have a list of factors that we consider to be dispositive. We're also not going to tell you how to balance them. The other notable thing that the court said in Graham versus Connor is that if you have other provisions of the Constitution that you think might really govern that use of force, so equal protection, you think that maybe police officers are using too much force in some cases and not as much in others, or due process, or something like that, that sounds like maybe it would apply to the use of force. The Supreme Court says, no, the Fourth Amendment is really the one and only amendment that governs the use of force when police are seizing and arresting people. So the final of these three cases is a case called Scott versus Harris. And this is a case where police officers used, again, what they say is deadly force, which is they apply the bumper of a police car to a car containing a person who's trying to evade the police. Both of them are traveling at high rates of speed. And the person who is stopped in this case ends up paralyzed and so fairly seriously injured. And so the question is, given that the kinds of offenses that he was suspected of were driving-related offenses, so not offenses that are the kinds of serious risk of death or bodily injury that maybe it sounded like the court required in Tennessee versus Garner, is the police use of force, deadly force, reasonable in this case? And this is where Justice Scalia, writing for the majority, says that reasonableness, really, it does not have factors. We cannot give you a test. It might have sounded in Tennessee versus Garner like we were doing so. There is no such test. He says, and these are very helpful words, right? Courts must slosh our way through the fact-bound morass of reasonableness. So what all of this is to say is that absolutely there is a provision of the Constitution that constrains police use of force. It is the reasonableness requirement of the Fourth Amendment that police officers be reasonable when seizing people. But we don't have a test for what reasonable means. We don't have factors necessarily to consider in deciding whether or not the use of force is reasonable. We're just sort of supposed to balance the state's interest against the individual's interests, maybe taking into consideration, but not using it as dispositive, the offense that has been charged or suspected. And so that's the guidance that the Constitution provides. If you're interested in how that actually applies, you may want to watch the short explainer on qualified immunity.